38 days. That is the precise window remaining before 5 distinct legal mechanisms activate, potentially rendering your concealed carry status null and void. We are not discussing theoretical bills languishing in committee or legislative posturing. We are talking about January 1st, 2026. These are codified changes with hard implementation dates. If you possess a firearm or carry concealed, the probability of at least one of these vectors impacting your liberty is near absolute. We are analyzing everything from the liquidation of the $200 NFA tax requirement to aggressive state-level restrictions capable of converting law-abiding citizens into felons overnight. Some of these triggers have already been pulled as of November 2025, and the vast majority of gun owners remain blissfully unaware. By the conclusion of this briefing, you will possess the tactical knowledge of exactly what is shifting, the timeline of enforcement, the specific jurisdictions under siege, and the critical maneuvers required immediately to remain on the right side of a prison cell. I am going to outline specific deadlines, the severe penalties for non-compliance, and the immediate action items. We are breaking this down into 5 critical shifts, commencing with the most significant federal adjustment we have seen in decades. Change number 1. On January 1st, 2026, the $200 NFA Tax Stamp fee is being terminated. This applies to suppressors, short-barreled rifles, short-barreled shotguns, and any weaponry categorized as AOW under the National Firearms Act. However, before you celebrate, you must understand the nuance. The registration requirement remains absolute. You must still register these items with the ATF. The surveillance apparatus is not shrinking, only the entry fee is. This statute was signed in July 2025 as a component of a broader firearms reform package. Here is the operational impact for your defense strategy. If you have been delaying the acquisition of a suppressor for home defense to preserve your hearing, or an SBR for vehicle operations, the financial barrier has been removed. We anticipate a massive influx of owners accessing NFA items beginning January 1st. But here is the trap. If you have a pending Form 4 application right now with that $200 already paid, you are locked in. The Bureau is not issuing refunds. If you paid that fee in November or December of 2025, consider those funds confiscated. Therefore, if you intend to acquire an NFA item and the paperwork is not yet filed, hold your position until January 1st. Mark the calendar. January 1st, 2026. That is the activation date. Be advised, dealers are soliciting pre-orders. That is acceptable, but you must ensure the actual Form 4 submission occurs on or after January 1st, absolutely not before. Scrutinize the fine print on any dealer agreement. If you are maneuvering to buy a suppressor or SBR, execute your research now. You must understand your local jurisdictional hazards. Despite the federal fee elimination, specific states maintain total prohibitions. California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, Hawaii. In these territories, suppressors remain illegal regardless of federal tax adjustments. Furthermore, realize that the bureaucratic gears grind slowly. Even absent the fee, you are facing ATF processing times of 90 to 180 days for approval. The removal of the tax does not expedite the background check. You must still submit fingerprints, passport photos, and endure the federal vetting process. Now we must address the consequences, because this is where the felony tripwire lies. Possessing an unregistered NFA item post-January 1st remains a supreme federal felony. You are risking 10 years in federal penitentiary and a $250,000 fine. The tax is gone, but the registration is mandatory. The ATF will prosecute possession of unregistered items with extreme prejudice. Bottom line, wait until January 1st to save the capital, but do not attempt to bypass the registration. The agency does not care that the fee is zero. They will incarcerate you for an unregistered unit. That covers the federal financial adjustment, but the individual states are mobilizing, and some traps are already active. Change number 2. This mechanism triggered on November 1st, 2025. Most owners missed it entirely. The U.S. Sentencing Commission has amended the federal sentencing guidelines regarding firearms offenses. The penalties for straw purchases, falsifying Form 44673, and illegal transfers have escalated dramatically. Let me clarify the definition. A straw purchase is the act of acquiring a firearm for another individual who is prohibited. If an associate with a felony conviction provides you cash to procure a weapon for them, that is a federal felony. Prior to November 1st, the liability was up to 5 years. Under the new draconian guidelines, you are now facing up to 10 years. The ATF is actively hunting these transactions. They are cross-referencing Form 4473s against financial data, social media surveillance, and retailer video feeds. In 2024, they prosecuted over 300 cases. Expect that statistic to skyrocket in 2025 and 2026 because the enhanced penalties have made these priority targets for prosecutors. Here is the secondary trap, lying on Form 4473. Question 21E regarding unlawful use of marijuana or controlled substances. Even if your state has legalized it, it remains federally illicit. If you utilize marijuana and mark no on that federal document, you have committed a felony. Under the new guidelines, the prison exposure has jumped from 2 years to 5 years. The agency is cross-referencing 4473s with state medical marijuana registries where available. They are scrubbing DUI records, possession charges, and social media footprints. If you post photographic evidence of drug use online and purchase a firearm, 2 weeks later, that is admissible evidence of perjury on a federal form. Your defensive protocol is clear. Never purchase a firearm for another party, regardless of the relationship or the funding. If they cannot clear the background check, you cannot be the proxy. Period. Second, answer Form 4473 with absolute truthfulness. The databases are vast, and they will flag the discrepancy. If you are transferring a weapon to a family member, know the statutes. In most jurisdictions, immediate family transfers are exempt from FFL requirements, but the recipient must be legally eligible. If they are a prohibited person, felon, domestic violence offender, drug user, you cannot gift them a weapon. That constitutes an illegal transfer. The new sentencing guidelines translate to significantly longer incarceration, and prosecutors are eager to utilize them. Do not gamble 10 years of your life to assist a friend. Federal enforcement is hardening. Change number 3. We now focus on a state executing a major overhaul of the transfer protocol. Colorado is erecting a bureaucratic firewall that activates on August 1, 2026. This comes directly from Senate Bill 3, ratified in April 2025. Effective August 1st, any citizen attempting to purchase a semi-automatic firearm in Colorado is mandated to complete a state-sanctioned safety training course and secure a government permit before they can take physical possession of the asset. Understand the nuance here. This is not a ban on the hardware itself. You can still transact for AR-15s, semi-automatic pistols, and shotguns. However, the state is blocking the transfer of custody until you submit to their curriculum and obtain their permission slip. The mandated course is a minimum of 4 hours, covering safe handling, storage protocols, Colorado statutes, and a live fire qualification. Here is the operational intelligence for concealed carry holders. If you currently hold a valid Colorado concealed carry permit, you are exempt. Your permit satisfies the state's requirement. However, if you do not possess a CCW permit and you intend to acquire a semi-automatic weapon post-August 1st, you must complete this training first. The financial cost is estimated between $75 and $150, but the real cost is time and registration. For those migrating to Colorado or planning future acquisitions, you must understand the grandfather clause. If you already own semi-automatic firearms within the state prior to August 1st, 2026, you are not required to obtain this permit retroactively for your existing inventory. But if you initiate a new purchase after that date, the requirement triggers. The critical vulnerability lies in the expiration. This permit is only valid for 5 years. After that window closes, you must renew it via a refresher course. This is not a one-time hurdle. It is a recurring subscription to your own rights. The training must be administered by a state-approved instructor. Colorado is currently certifying these entities, and the master list will be published by the Colorado Bureau of Investigation by June 1, 2026. Ensure your instructor is on that list, or your certification is worthless. If you are a resident of Colorado, your action plan is simple. If you have the CCW, you are secure. If you do not and you plan to buy semi-automatic hardware after August 1st, begin identifying approved courses immediately. We anticipate these slots will reach capacity rapidly as the deadline looms in July 2026. The legal consequences for circumvention are severe. Taking possession of a semi-automatic firearm without this permit after the deadline constitutes a Class 2 misdemeanor. You are risking 120 days in jail and a $750 fine. Furthermore, the dealer who transfers the weapon without verifying your credentials faces identical penalties. Expect dealers to be rigid and unyielding regarding this paperwork starting August 1st. Colorado is not the only jurisdiction tightening the screws. We are seeing even more controversial measures elsewhere. Change number 4. Kentucky is implementing an extreme risk protection order law, commonly identified as a red flag law, effective February 1st, 2026. This was passed in March 2025 and signed in April. Kentucky becomes the 22nd state to activate this mechanism, and the version they have adopted is exceptionally expansive. Here is the operational reality. Family members, household residents, and law enforcement officers can petition a court to issue an order against you based on the belief that you pose a danger. If the court grants this order, you are legally compelled to surrender all firearms within 24 hours. Your concealed carry permit is suspended immediately. The most dangerous aspect of this statute is the element of surprise. This suspension can occur ex parte, before you even receive a hearing. You do not get advanced notice. The first indication you might receive is law enforcement arriving at your residence demanding the surrender of your property. The list of potential petitioners is broad: current or former spouses, anyone you have cohabitated with in the past year, blood relatives, in-laws, anyone you have dated in the last 12 months, and any police officer. The standard of proof for an emergency order is reasonable cause to believe, which is a dangerously low legal bar. If an order is filed, your defense rights are delayed. You are entitled to a full hearing within 14 days of the emergency order where you can present evidence. However, during that 2-week interim, you are disarmed and your carry rights are nullified. If the court solidifies the order at that hearing, the confiscation can last up to 1 year, renewable upon further petition. If you reside in Kentucky, you must understand the threat landscape. If you are navigating a divorce, a custody battle, or familial conflict, you must document every interaction. Keep records of communications and witnesses. Once an ERPO is filed, you are fighting from a defensive posture. If you are targeted, retain legal counsel immediately. Do not attempt to navigate this pro se. This is a battle for your Second Amendment rights, not a traffic court dispute. You need a specialist in firearms law, and you need them instantly because that 14-day clock is ticking. The penalty for violating an ERPO is catastrophic. Possession of a firearm while an order is active is a Class D felony in Kentucky. You are looking at 1 to 5 years in prison. Even after the order expires, the return of your property is not automatic. You must petition the court for restoration. Change number 5. While states are restricting, there is one federal proposal that could override the entire map. The Constitutional Concealed Carry Reciprocity Act, H.R. 38, was reintroduced in the House in January 2025. If this bill passes, and there is a viable path in 2026, it would mandate that all 50 states recognize concealed carry permits from any other state. This would represent the most significant expansion of carry rights in American history. Currently, reciprocity is a legal minefield. Texas is recognized by 42 states. California recognizes 0. If you cross from a permissive state into a restrictive one like New Jersey with your firearm, you are committing a felony. H.R. 38 would standardize this. Your permit becomes valid nationwide, functioning like a driver's license. A Texas permit would be valid in California. An Arizona permit would be valid in New Jersey. States would be prohibited from imposing additional burdens on out-of-state permit holders. The current status is critical. H.R. 38 has over 213 co-sponsors in the House. It is currently sitting in the Judiciary Committee. If it clears the House, it moves to the Senate, which remains the primary obstacle. However, a critical warning is necessary. Do not operate as if this is law. It is a bill. It is not enacted. Even if it passes, we anticipate immediate court challenges from restrictive states creating an enforcement gray zone. Until you see the presidential signature and the survival of judicial review, you must adhere to current reciprocity agreements. If you travel interstate, verify the maps. Do not assume protection that does not yet exist. Here is your immediate action plan. Mark these dates in stone. January 1st, 2026, NFA Tax Stamp elimination. February 1st, 2026, Kentucky's red flag law activation. August 1st, 2026, Colorado's training mandate. Remember, the federal sentencing guideline hardening is already active as of November 2025. Verify your state's status regarding these changes immediately. If you are in Colorado or Kentucky or transact through them, you are in the impact zone. If you are buying NFA items, wait for January 1st to save the tax, but do not skip the registration. And finally, never falsify Form 4473 or engage in a straw purchase. The risk calculation has shifted permanently against you. The legal landscape is mutating faster than ever. To survive, you must stay informed.